Senator McConkey is going to lead us in the pledge. Thank you. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice. Thank you, Senator. We're starting with executive session.
Motion to go into executive session.
Second. Okay. Okay, we're going to start off with HB 75, and I have a motion to ITL. Do I have a second?
Second.
Quick seconds. Let's see, 75 is legalizing cannabis for persons 21 years or older.
Wait. Are we on 51?
No, I'm doing 75, Senator. I'm sorry. I apologize. No, we're doing 75.
75.
53 will be second, 51. I mix the signals to.
So the discussion is open on 75
Yes, ma'am. I'm going to.
with an ITL motion. Is that correct?
Yes, ma'am.
Got it. Thank you.
Okay, thank you. So my thoughts were no safety rails, no quality control if someone's growing it in their yard. We'll have to pay for, any problems that are related to it. We're gonna have increased poly use. I'm not gonna know what's in those drugs when they're out there. Anyways, it's so further beyond with no safety rails than we've ever discussed going before. It just seemed like it was trying to jump the river without putting the bridge up. So that's why we're here at ITL. Any other thoughts?
Well, Mr. Chairman, I'll just say that if anyone was here last term, there was a very limited version of this I would ever consider supporting. And having no regulation whatsoever, this could be anywhere, everywhere, without consequence. We would basically be
Wild West.
that's one way to put it. I'll support the ITL.
Thank you. Other thoughts?
Thank you, Mr. Chair. I think in my, this is now my 9th year of service in the legislature, and every year we have bills that come before us looking to find an avenue for legalizing adult use of cannabis. And it is my experience that we are always letting the perfect be the enemy of progress. And if we don't just start taking some baby steps, we will talk ourselves out of doing this at every turn. And so I will not support the ITL because it's time for us to just take a step.
I certainly appreciate the logic. I think that time was last term. I think that for me, that opportunity is just the ship sailed, and we passed it in here. It was heavily regulated. This is not regulated at all. So I think really where the most important part is how do we regulate and govern this, and this is way too much for me to go in this direction.
Well, maybe that's something we can talk about at the committee of conference that I would like to put some regulations in.
Sure.
So
For me, this wasn't baby steps. This was putting the baby in a marathon. You're just skipping over everything else with no guardrails. Senator, do you have other thoughts? Okay. So we have a motion of ITL. All in favor of the motion? Aye. And Senator Elsha? You're a no. Okay, thank you. 3-1. I'll take it out. Thank you. We're going next to 53. It was permitting qualifying patients, designated caregivers to cultivate cannabis. As Officer Sullivan said, it would allow up to 8 ounces, half a pound of cannabis. And I am introducing an ITL motion.
Second.
Other thoughts? Go ahead, Senator. I'm sorry.
thank you. No.
Daryl's big, and so when he leans forward,
Yeah.
I don't see it.
Thank you, Mr. Chair. In fact, I think some of the most compelling testimony we heard was from survivors of cancer who actually are using cannabis as part of their therapeutics. Particularly our colleague, Representative Wendy Thomas, and Alicia Bennett, who, told us her experiences as a cancer survivor and an amputee, having lost her right arm. And she is challenged by the affordability and the access to get the particular kind of strains that actually give her the results she needs. And hearing from the Honorable Dr. Jerry Kirk and the same in the Honorable Dr. Joe Hannon, we know that the Therapeutic Cannabis Medical Oversight Board is in favor of this, and that they see home cultivation as a way to provide affordability and accessibility to patients, given particularly that we have such little access to ATCs, and that the people who would take advantage of this program are so minuscule, but they're asking for just a little help. And so giving them the opportunity to put a fenced in and covered space in their yard or, in their house to be able to grow what they need to, live a productive and pain-free life seems like such a very, very small thing that we can do to improve the lives of Granite Staters who are suffering, genuinely suffering.
Other thoughts, Senator? Go ahead.
I would just point this out as a matter of construction here. If this were to become law and you were to apply it, if you get approved to home grow, you are just simply allowed to possess 8 ounces of cannabis, irregardless if you're actually growing, the way I read this. So this is, to me, really, for all meaningful purposes, expanding the possession limit to...
Where is that? Are you on page, where do you see that?
The words I am using are my own words.
I believe,
But if you look at lines 8 and 9 on page 2.
On page, okay.
A qualifying patient or designated caregiver possesses or cultivates an amount of cannabis that does not exceed the following: 8 ounces.
Mm-hmm.
So it doesn't necessarily mean that they actually are cultivating what they're possessing. To me, this is a kind of a backdoor way of making an 8 ounce possession limit. Of course, you have to be approved for the cultivation, or as a patient who is allowed to cultivate. So with that being said, we heard testimony, and I appreciate the honesty in the answer, that they don't even have a meaningful way of determining what you possess is actually what you've grown. So there's no realistic way of enforcement of that. So I think this policy I have a lot of concerns with, but coming out of the gate to 8 ounces is a non-starter for me. But the way I see this is, and the way it was presented, no one seems to think that was a problem. And this is really, to me, just increasing the possession limit. And through all the hearings we went through last year, when we talked about what should the possession limit be, everyone says no one ever buys that much at a time. No one ever buys that much at a time. So here we have 8 ounces. And the other part of this is that patients are allowed to, obviously they can't exchange money for it or anything in return for it, but they're allowed to, transfer this amongst each other, as long as there's nothing exchanged for it. So not only is this a very large possession limit, there's really no way to track where it's going. And I think this is something I'm not ready for, but especially that. That's just my opinion.
go ahead, Senator.
Thank you. Thank you, Mr. Chair. And thank you, Senator Abbas, for pointing that out. I think that perhaps, though, if we back up to line 1 of that, it contextualizes what's happening when you get to the concerning lines of lines 10 and 11, in that it says, except as provided in RSA 126X3, Part 7B, a qualifying patient or designated caregiver who has reported to the department a cultivation location that meets the requirements of this chapter shall not be subject to arrest by state or local law enforcement, prosecution or penalty under state or municipal law, or denied any right or privilege for the therapeutic use of cannabis in accordance with this chapter if at the cultivation location while transporting cannabis and cannabis plants and seedlings to a new cultivation location that has been reported to the department within the prior 21 days, or while transporting cannabis seedlings from an alternative treatment center to the cultivation location, the qualifying patient or designated caregiver possesses or cultivates an amount of cannabis that does not exceed the following. And then we have the 8 ounces. Yeah. So what we learned in this bill, though, is that there is an opportunity for people who are too sick to cultivate, who are too sick to do the farming, but they don't live close to the ATC. We did hear testimony that it is okay within this bill for a caregiver to take care of their plants. And that caregiver could also take care of someone else's plants. And so this section is actually about transporting the seedlings from an ATC for distribution to the people who are going to be doing the growing. So it's not saying that they're going to leave 8 ounces of usable cannabis at that person's location. They're transporting the seedlings to a location, and that in this section of the law, that transportation, if somebody has 8 ounces of usable cannabis, they are in the process of bringing it to people who are going to be doing the cultivating, that they cannot be subject to arrest for having over the legal limit, because there's a purpose for them to be having over the legal limit. So this is actually the carve out for the qualifying patient or designated caregiver. So this is for people who are going to get their seedlings or maybe a little bit mature plants to bring back. This is not about leaving 8 ounces of cannabis in your car and being given a free pass for not necessarily being arrested for intent to distribute. This is about getting things from point A to point B.
I understand, and thank you for reading it. If you look at cultivation location is defined on page 1, lines 3 to 7, which includes the location that has been designated for the patient, which
yes, yeah.
So and then this paragraph on page 2, it begins with a qualifying patient or designated caregiver. And it gets into, you're right, it says seedlings, it says plants, but it also just says while transporting cannabis. So it also just includes that straight cannabis word as itself, and then it goes at the end, again, the qualifying patient designated caregiver possesses or cultivates an amount of cannabis, right? But it says possession of cannabis as well. It says possesses or cultivates. I'm just saying, what you just said is correct, but also what I'm saying is correct. So we're both actually right, but you're talking about perhaps the intent of what this would do, which I understand that policy, but I think an unintended consequence is what I'm talking about. So I think we're both actually, I don't think our interpretations are any different. But to me, this just goes too far, so I'm not.
Okay, well, would you be open to a friendly amendment so that would clarify that this is about the movement of seedlings and cannabis to what is referenced at the top of page 1, RSA 126X1, which is right here on line 8, also on line 1. So it keeps referring back. But would you be open to a friendly amendment to clarify that a little further, just so there's not that question?
I would not be, because I think the issue I talked about is that The problem is that qualified patients can actually just literally hand it out amongst each other without any real way of controlling that or even monitoring it. So whether it's 8 ounces, 6 ounces, whether it's sealant, whatever, I'm not there yet.
But so what you're implying is that people who have ATC cards and have achieved the status of getting that card because they are desperately ill, usually with cancer, or like when someone came in here, lost a limb, or are experiencing PTSD, those people, you are implying that they would take the medicine that they need and that they have sought after, most of them, so that they do not have to engage in opioid use. This is a different way of getting that kind of relief. You're insinuating that they're actually going to be dealing on the side of their own medications?
No, I'm not implying that at all.
Okay,
The problem is that
You just said that they
the
would be
problem
selling
you
it.
have is that when you have laws in place, honest people like myself and yourself and Senator Gannon, and see how you do on this. But honest people, I'm not worried about, but laws can be taken advantage of, and that's when we draft a law. I think we need to be responsible in how we do that. And I'm not at the point where I think this is a policy that I'm going to support, especially as it's written.
Okay, you both made good points. We'll move the question. All in favor of the ITL motion?
Aye.
Aye. Opposed?
Nay.
3-1. You want to take it out?
I can take it out.
Okay. Senator Abbas will take it up. Okay, this was relative to the purchase of hemp-derived CBD. I have an ITL motion.
So what number are we?
I'm sorry, 51.
51?
Yep, we're not doing 196 today.
Second.
So I have a second on the ITL motion on 51. Any discussion?
Mr. Chair, would you care to elaborate on where your ITL motion is coming from?
Sure. Do you want to go into what we were talking about earlier? Senator Abbas will.
Sure. One part, and I think there's other parts of the, I think therapeutic use, therapeutic cannabis chapter that may need to be cleaned up. But this has a provision there that would literally, I know it's only a small amount, that what we heard is not enough to make someone feel the effects of being impaired, or I guess stoned is the term we'll use. But it does allow for them to use synthetic THC, which I thought was unusual to allow the therapeutic facilities to allow that. I would, at some point in my own time, go through the rest of the therapeutic cannabis chapters. I don't think they should be selling the synthetic version of THC. I don't care if it's traces amount or enough to actually have an impact on it. If they're cultivating actual cannabis, why would they have synthetic THC in their products? That was one part for me that was a non-starter. But to expand on that policy in any level, I'm not willing to do that. If anything, I would want to prohibit them from selling synthetic THC altogether. And I prefer them to sell, if they're going to sell something, it should be the actual THC, especially if they're growing it themselves.
Thank you, Senator. Go ahead, Senator.
Thank you, Mr. Chair. So the point of this bill, though, is really highlighted in sections 14 through 18, that an alternative treatment center may acquire and may use in the manufacture of cannabis concentrate and cannabis-infused products, CBD and other hemp-derived non-intoxicating cannabinoids not produced by an alternative treatment center in New Hampshire. All non-intoxicating cannabinoids and all cannabis concentrate and cannabis-infused products manufactured from such non-intoxicating cannabinoids shall be tested for contaminants and cannabinoid profile in accordance with this chapter, which speaks to what we heard in testimony is that the alternative treatment centers are currently growing this and creating their own and using their own growth, right? They're using their own stuff to grow and create these products. And that is becoming cost prohibitive. And it is having a consequence of their products being more expensive than surrounding states. And what they're asking for is an opportunity to bring in these ingredients and not be bound with having to grow all of their own ingredients. So the synthetic cannabinoid is an ingredient, right? When you can use 100% Madagascar vanilla if you want to make a creme brulee, or you can use McCormick imitation vanilla. They're both vanilla, and maybe you made your own vanilla at home and it's far superior, and that's great for you. But not everybody has the opportunity to make their own vanilla at home and spend the time soaking the vanilla beans and waiting it out the 6 months that it takes, or can't afford to get the organic Madagascar vanilla from the specialty bake shop. And McCormick vanilla is actually just fine. And the McCormick vanilla is not 100%. It actually has some synthetic additives in it, but it still tastes like vanilla, and you still can bake a delicious cake with it. And this bill is the ATCs are asking us, may we please bring in some ingredients to make the products that our patients need, and we can make it for them at a reduced cost by sometimes not using every single product that we have to create ourselves. So they're just looking for more ingredients so that they can make the tinctures, so that they can make the fruit chews, so that they can put together the capsules that have the ratio products that the supporters are saying, I need. We had patients come in and say, I need this stuff. I don't want to take opioids. I want to take this. And they just want an opportunity to buy some less expensive ingredients to meet the need of their patients.
Senator, can I ask you a question?
Yes, sir.
Thank you. So if this was materials that were bought from out of state, who would be testing and regulating and making sure it doesn't go beyond 0.03? Is that where you're going to have to then rely on out-of-state testing?
But so funny enough, we have a sheet, might be in the last folder, of the surrounding states that actually do all their testing on their ingredients and products, because they are,
My question is,
they're ahead of us.
We're going to have to rely on their testing? The stuff that they ship in?
Kind of like the way we rely on their testing for their food and their cars and all the other stuff that we bring in, and they have to rely on our testing for fireworks. So, I mean, yes, we rely on each other. That's how interstate commerce works, that we rely on what is produced in one place to, meet a certain standard. And also, we have an opportunity to test on our own. The ATCs have said that. In fact, Matt Simon said, and the lab allows for New Hampshire ATCs to buy federally regulated hemp products and then lab test them here for sales. So the opportunity is here too. They can do that.
So my understanding is that if they want to buy vanilla extract from outside the state of New Hampshire, they still can. So I don't think that that's the issue here.
Well, they can't buy synthetic cannabinoids because we don't let them yet. So we would like to let them use that. It's an ingredient.
So that's the chemical. So basically, I run that parallel. It's obviously they don't have the same effect, but what heroin is a natural substance that's made into a drug. Fentanyl does virtually the same thing, but it's a synthetic drug. To me, Delta 8, Delta 9, although it does has the same effect as THC, it's the synthetic version of it. And all I'm saying is they want to be able to have trace amounts of that in their product. Apparently, it's not even enough to do anything. I'm not sure why the chemical is being added to this if it doesn't do anything. But if they're going to have any trace amounts of THC, I'm not supportive of it being the synthetic version of it. And I don't care if it's a trace amount, if it's enough to make you impaired or not. There's no reason why an ATC or anyone in this industry should be selling the chemical version of THC. So for me, they're adding a chemical to this for whatever reason. I'm curious why. When it comes to the out of state, of this, my understanding is they can own an interest in out of state companies as well. They're not just exclusively operate in New Hampshire. So then we're going to have that over state lines. They're just finding a way to bring some of the stuff in here when I'm not sure every state offers us the same return. We didn't get any information on it. So I'm going to support the ITL for now.
I'm sorry, may I ask a question, Senator Abbas? You just said you're not sure if any state offers us in return. What would we be offering them? Because we don't have the robust markets that all of our surrounding states have. Like, we're the one at the deficit because we need these ingredients to come in from other states because we are only bound by what we can grow ourselves at our own ATCs and then produce. So what is it that you think that would not be a reciprocal relationship? What could we offer? What do we have that they don't?
I'm just curious what the other states' policies are. Would they be allowed to purchase these products from New Hampshire? We didn't get any information on that during the hearings.
I don't know. If I may, what we heard was that the other states already have this stuff and that we need it. So we want to get it from them. Why would, they already have this. So, and we need this ingredient in order to reduce the costs on the ATC, on our ATCs, which then is passed on to the patients of the ATCs. And they're asking us, can you please help us out by letting us buy this regulated ingredient from other states that are already been doing this for years, and we just need this ingredient too, please.
No, I understand what you're saying. I'm wondering if those other states, are they allowed to buy it from New Hampshire? I don't know. Each state has.
There's nothing to buy because we don't make it. That's the point. Why would they? We don't have anything to offer them. That's why we're asking it from them.
We make some of the stuff here, but anyway, I'm going to support the ITL. I do appreciate the points that you're making.
Thank you, senators. Okay, on the ITL motion, how do we, all in favor of ITL? Aye. Opposed?
No.
Okay. You want to do it?
Sure.
Okay, thank you, Senator. Okay, that does it for the exec. We're going to do the other bill 196 on another day. What's that? Okay. Motion to go out of executive session.
Do we want to put any of these on consent?
Would you do consent, Senator?
Nope.
No, I didn't. Okay.
No, no ask, no get, right?
Sure. Coming out of this.
Can't blame you for trying.
No, not even a little bit.
Senator Abbas is second, and
Second.
all in favor of moving out of exec?
Aye.
And we'll take 5 minutes and we'll start the new hearings. Take a 5-minute recess. Thank you. Yep. Senator Leon, good to see you. You're introducing 291 for us, and I'm interested very much because I live on a pond and people have fertilizer, so you caught my interest days ago.
Thank you very
You're welcome.
much. Thank you. For the record, my name is Erica Leon, and I represent Rockingham 13, which is the town of Derry. I introduced this bill because last term there was a bill on application of fertilizers where we overturned the governor's veto. I noticed that there was a problem with that language because it was set into the section about the sale of fertilizers. So all of the penalties were what you would expect would be appropriate when somebody who's engaged in the business of selling fertilizers breaks the law. However, this is about individuals and companies applying fertilizer in an incorrect way. That law did say that the stores need to have signs about how to sell the fertilizer and not to sell fertilizer that violates the statute. However, not everybody shops for their fertilizer every year. Some people have old bags in their garage. And as more of an ongoing issue, people also shop out of state. I know we're the sales tax free area, but sometimes you just need to grab that fertilizer on your way home so you can get your chores done. This bill was amended in the House Criminal Justice in order to give a nice graduated step where the first is a warning, and then a violation with a fine, and then a misdemeanor. It specifically does not require each of those to go through the entire process. So if Joe's Green Grass comes around and is misapplying fertilizer to 4 houses around your lake, Senator, they could be subject to that misdemeanor, because even though they're done in quick succession, should they know, it can absolutely be applied as a misdemeanor, even if they're all happening within the same day. You know, there's a question about how you would apply that. I'm sure that an individual may get grace if they happen to own contiguous properties like I do. But if somebody is engaged in the process of fertilizing and really should know better, we should have that book so we can throw it at them if necessary. So with that, I'm happy to take any questions.
Just a legal question for you, which I should probably know and I don't. You said the 4 in a day. Wouldn't you? You'd have to have a conviction already for the other ones to be treated as misdemeanors. So I think if you did 4 in a day, you had no convictions. I don't think they could get you on that being a misdemeanor for the 3rd or 4th. I think until you had a conviction, it would be 1.
Okay, it was my understanding over in
But I
the
could
House
be
Criminal
wrong.
Justice, but this definitely isn't my area of strength.
Okay, it's
So-
not a big deal right now. Okay,
Okay.
thank you very much for your testimony.
Thank you.
Any other questions?
Sorry. Thank you, Mr. Chair. Did you say there's someone coming behind you that, or would you entertain a question?
So my co-sponsor is the chair of Environmental Agriculture, whose committee it went through last year, and she's in support of doing this. Also, New Hampshire Lakes is here and they support this. Everybody came together in the House to support this process so that we can have the leniency where needed and have the strength of law where necessary.
Oh, go ahead. Are you done?
No, not yet. Just, so your example that you used, this is, I understand this play out if I did it myself. And then, but if there's a lawn care company and like I'm in a neighborhood where one of the lawn care companies has like 4 accounts, you know, they do 4 different yards in our neighborhood. So if they did this in the neighborhood, are you saying like that day would be a first offense for that corporate agent, basically? That wouldn't be 4 different offenses because it was 4 different properties. Did I follow you correctly?
Sort of, but I don't
Okay.
have the full answer on that. The intention is that if somebody's going through even on the same day and applying it to multiple clients, that we would be able to catch them in this net. If you need to fix the language to make it do that, I'd appreciate the help. But the intention is so that your average homeowner doesn't get a misdemeanor just because their neighbor doesn't like them and was reading the bag on the fertilizer or keeping track of when
Gotcha.
they were fertilizing. And it's not to get bad landscapers, give them a pass.
Senator, you had a question?
Thank you, Mr. Chairman. Representative, thanks for taking my question. I'm still a little uncertain here. So I've heard a corporate agent group comes in and, hey, I'm doing my neighbor, I can do yours. I could see where that would multiply right away. The clock starts, so if it's an individual, a homeowner, and I'm not in favor of this, I live on a lake. So if that person gets caught with a violation today, 3 years from now, he would move and he went to fertilizer, he missed a year, came back 2 years later, he'd receive a $250 fine the second time that person does that. And then on the third time or any time after that, it becomes a misdemeanor. Is that the intent here?
That's my understanding of it. Right now, it's currently a misdemeanor. So this is trying to give a more gentle glide slope for your average homeowner, just so that if they're using their old fertilizer, if they bought it out of state, they're not subject to a misdemeanor. This was just intended to make it easier on that person if you want to do it within a certain amount of time, stating that multiple applications in a day can be treated as individual, multiple separately owned properties, however you want to do it, so that you're catching the landscapers without getting, Joe, who's done one of his properties, went inside for lunch, went back out to do the other half of his lawn. You're the Judiciary Committee. I trust you to have that language, but the intention is to give leniency to individuals while making sure that anybody who's either acting maliciously or somebody whose business plan is to maliciously apply too much fertilizer is appropriately held to account.
Thank you, ma'am. Thank you, Mr. Chairman.
Thank you.
Thank you.
We're good. Thank you very much.
Thank
Good
you.
to see you. Representative Judy Aaron. Good afternoon, Representative. How you doing today?
Good afternoon. I'm well, thank you. So for the record, my name is Representative Judy Aaron. I represent Sullivan County District 4, the towns of Ackworth, Goshen, Langdon, Leominster, and Washington. And I am Chair of the Environment and Agriculture Committee in the House. And I'm just here today as co-sponsor of this bill to echo what Representative Leon has brought to you, and also to let you know that we felt, the original underlying bill of making sure that fertilizers don't get abused and end up in our lakes and streams and so forth. We passed that through our committee, and Environment and Agriculture felt it was very important. And I guess we're neglectful into what the penalties were for that. And so this bill seeks to fix that and put the penalties in line with what the act would have, would be. So I just wanted to reiterate my support and also my committee's support for this bill.
Thank you very much. Questions?
Thank you.
Thank you very much.
Appreciate it.
Andrea Lemieux. Lemieux? Andrea, I'm a good Irish guy, so I'm working on the French.
It's Lamoureux.
Lamoureux, okay. My neighborhood, everyone was Fitzy, Murphy, Sully. Sorry.
You don't have to be nice. That he wasn't close.
No worries. Well, good afternoon. I'm Andrea Lamoureux. I am the president and policy advocate of New Hampshire Lakes, statewide nonprofit member-supported organization. Our mission is to restore and preserve the health of our lakes. And we are here today in support of this bill, reiterating all that Representative Leon and Aaron just said. We really appreciated the opportunity to work with both of the representatives in the House to get this bill amended. Again, the intent on being graduated penalties, to protect those homeowners that just don't know about this or had some fertilizer they, used up. I think that if a homeowner were to, quote unquote, get in trouble for the misapplication of fertilizer, just getting the initial, warning really usually will turn them around. They probably didn't realize, that they were applying it inappropriately. And I think this goes after, sort of the bad apples, the bad actors who just repeatedly violate this fertilizer running into our lakes. I heard, Chairman, you live in a pond. We want to keep fertilizers out of our lakes. They contribute to water quality problems. And I'm sure you all heard about Lake Winnipesaukee and its water quality problems, and which may be contributed to the misapplication of fertilizers. So with that, I hope you support this amendment, and I'm happy to answer any questions.
Thank you very much. Go ahead, Senator.
Thank you, Mr. Chair. Thank you, Ms. Lamoureux, and thank you so very much for your advocacy. We appreciate it. My question is about outreach. How are we going to let people know that this is going to be a thing?
That is a great question.
Yeah.
Thank you for the question. And outreach is what New Hampshire Lakes, my organization, does really well, I think. And we will incorporate this. We have, many supporters. We have a Facebook page with 10,000 supporters. We go out and do active projects on people's property. We deliver what's called a Lake Smart, Lake Friendly Living program, providing property owners with free services, free site visits to tell them about how they can live more lake friendly. And this will just be incorporated into all of our outreach.
Yes.
So, as an example, I've had just recently received some outreach from a neighboring state. My mother lives in a neighboring state, and her lawn care company came, and I brought in, they put the little thing on the door, saying we were here today, and here's what we did, and so on and so forth, like, as they all do. But this time, there was a letter from the state's Department of Environmental Services that outlined some of the issues that had changed in the legislature around the applications of fertilizers and what you could do to take care to let your friends and neighbors and pets in the area know that you have just applied fertilizer. And so I did a little digging, and it turns out that they did a cooperative with the landscaping companies to put this update in the folders when they go to people's houses. And I don't know that it's necessarily something that we would need to prescribe in the law, but perhaps consider if this goes to JLCAR, or just consider it in general, that there is, other states are also doing things like this and adding in that outreach that is official from the state. So just want to put it out there that, I'm glad we are also.
Thank you for
But
sharing.
that's how I found out about it in this other state.
Yeah,
So
thank you for sharing
you.
your experience. We are building relationships with landscapers, and that's a great idea. Regardless of what you decide to do here, partnering in and working with them on their outreach points, I think is a great idea. So thank you.
Thank you very much for your testimony. We're all set.
Thank you.
Does anyone else wish to testify who didn't remember to sign up or has a good idea or thought? Seeing none, I'll end the hearing. Thank you. Buzz, Representative Quano. Quick question for you, Buzz. Just before we start. On the last one, right, you have to be convicted of that first offense. And, right, nothing's changed in the law. Okay. Thank you. Just for my review. Thank you. Okay, 162. Go for it.
My name is Buzz Sure. I represent Portsmouth Ward 3, Rockingham District 26. I'm a co-sponsor of this bill with Representative Roy. It's a follow-up on a bill that Representative Roy and I and then Senator French put forward several years ago, I think when Senator Abbas was chair of Criminal Justice Public Safety, if I'm not mistaken, many years ago. And the original bill required that when an officer stops a car and wishes to ask for consent to search the car, he has to let the person know that they have a constitutional right not to consent to the search, and that can't be used against him. And before they once they get the consent, they need to have them fill out a form, sign a form. That's worked well. I've talked with several police departments. I'm a police commissioner in Portsmouth. They already did it. They had no problem with it. They do this for consent searches for other property too. This really, as Chair Roy described in the letter to the committee, this doesn't make sense to give this protection to people for their consent searches of the cars, but not consent searches of their homes, which are an even more private area than cars are. And this only relates to consent searches. It doesn't change law relating to other warrantless searches of cars. It doesn't change the law relating to exigent circumstances and any other search warrant exception that may apply to the search of a car. It doesn't change that. It simply says if you're going to do a consent search of a home, you need to inform them of this right and have them sign off on the form. And that form already exists as to cars. It's just a simple change to expand it to include other property. It's not a heavy lift procedurally for any police department to produce that form. It is slightly more than is constitutionally required by the federal and state constitution, but it makes sense. It's very intimidating when officers show up your door and ask if they can search. And this doesn't prevent them from searching. It just gives a little bit more protection to people who may not understand what's going on. As I said, I've heard of no problems with this applying when, as to the old law, a law that was passed several years ago, in terms of having people sign off on a consent for search of a car. And with that, more than willing to take questions.
Thank you, Buzz. Have there been instances where the police are you implying that they've pushed their way into the house? They're the guy in blue with the gun and are people feeling that they're being forced into letting them search their house?
I wouldn't put it that way. I would say that there is periodic litigation in one case or another as to whether the consent that was given was given under duress or not given under duress. So it's an issue that sometimes is litigated in cases. This actually makes that litigation less likely to occur. If there's a form that they've signed that says you had a constitutional right to refuse, and that couldn't be used against you, and you nonetheless agreed, that will make it harder for the defense, if they choose to litigate that issue, to actually win that argument. So I think it'll reduce the number of circumstances. But yeah, occasionally that kind of litigation happens. It's not awesomely frequent, but it happens.
Thank you. Senator Evans.
Thank you, Mr. Chairman, and thank you for taking my question. What, if any, impact would this have on our policy involving no-knock warrants?
If you have a no-knock warrant, then it's not a consent search, and it wouldn't affect that at all. The no-knock warrant basically says, you have a warrant to search this place. The court has issued a warrant to search the place, but and you don't even have to knock.
So if I understand you correctly, it wouldn't have any impact on our
None whatsoever.
policy. It's a follow-up. And my follow-up question is, you compared someone's motor vehicle to their home or their other property, whether it's a shed or whatnot. I think I look at them differently, and maybe if you can offer your opinion on how I distinguish them. When you're in a motor vehicle and you're driving and you're stopped by law enforcement, that in and of itself is a seizure. You're not just free to keep on driving. You have to stop. Where for your house, you don't have to even open the door if you don't want to. You're not under a seizure in that particular circumstance. So,
correct.
I understood, if I understood correctly, the policy for the motor vehicle was when someone is stopped and there's a Fourth Amendment seizure for constitutional purposes, people may get confused what their options are. That was at least the argument presented in favor of this policy when it first passed back when I was in the House. This, but how does that apply to your house? Because you're not under a seizure, you're not under duress, you're not, I mean, if the police knock on your door and you don't want to answer, you really don't have to.
I understand what you're saying. The origins of the legislation relative to car was what we had been seeing happen in particularly on I-95 was the police would stop a car. They would have reasonable suspicion to stop the car, which is what they would need to have. And then they would start a conversation with the occupant of the car that often went beyond the purpose for the stop. So if someone was stopped for speeding, they would start a conversation saying, where are you going? Where are you coming from? Et cetera, et cetera. And that didn't have anything to do with the substance of the stop, which arguably that conversation was unconstitutional. And the feeling was that the individual, the driver, had really no choice but to agree, didn't understand, but they had no choice but to agree to a consent search. So that was that circumstance. It's different when they go to the home, but there is this measure of what we see not infrequently is the police go to a home and they're looking, they want to talk to somebody in the home. And they stand there and they ask questions to whoever answers the door. Frequently, it's a spouse or a partner who answers the door, who knows nothing about nothing. And in that circumstance, the concern is that just the mere police presence is intimidating. And it feels like, conversations I've had over the 40 plus years I've been working in the criminal justice system, it just feels, the police presence feels intimidating. And this is just a measured way to give people a little better understanding of what their rights are in that moment. When the police are standing at their door, they don't know why they're there, they don't know what's going on, and they say, we would like to search your house. And it gives them a little more understanding of what's going on.
Thank you.
Cinderella Schiller.
Thank you, Mr. Chair. Thank you for taking my question. So in going through this, and I'm hearing you outline that this gives the person answering the door just a little more information. And I think if I'm following you, in line 5, in line 8, the person has the right to refuse to consent to search, right?
Yes.
I'm sorry, I should just back it up to where I was. So the law enforcement officer expressly informs the person, you don't have to let me into your house, right? That's number 1. And number 2, if you choose not to let me into your house, that cannot be used against you in a court of law.
Correct.
As part of a criminal investigation or as grounds for further detention. So while that is very, it's very informative, it does say, it does outline what won't happen. We've got law enforcement on the front steps, and they're saying, don't worry about it. If you don't let us in, we can't use the fact that you didn't let us in as part of this criminal investigation or as grounds for detention. What criminal investigation? What grounds for detention? You just showed up on my door. I don't know what you're talking about. So we're already in an adversarial relationship to begin with. And so I'm going back to, you said, the genesis of this bill. Did something happen? Like, what is this addressing?
It's addressing broadly two things. One, the specifics of motor vehicle detentions where they
Okay.
got dramatically expanded beyond the purpose of the original stop, number one. Number two, a long history of cases. I mean, I practiced as a public defender for 13 years, at this point decades ago, but I've talked to a lot of criminal defense lawyers over the years. For many years, I was on a listserv that just criminal defense lawyers on the listservs, and they would talk about this. They would talk about the police just showing up at the door and somebody's wife or partner or teenage son answers the door, and it's just like, whoa, as you described it, it already feels adversarial just because the police showed up. It's not the person probably that, well, it's as likely that the person they're really thinking about might be in trouble. It's just as likely they're not the one who answers the door as it is a spouse or a teenage kid or something like that. And I've heard stories over and over again about how intimidating that is. I know police officers, certainly the Portsmouth police officers, don't try and intimidate people into just by their mere presence. But the mere presence of a police officer on your doorstep is scary to most people. And all this really does is give them a little bit more information about what's going on. It's not like this is a full-blown set of Miranda rights. It's, look, we would like you to consent to us searching your house. You don't have to. And if you don't agree, that's fine. We're not going to, your refusal in and of itself is not going to be held against you. If you agree to consent, we just want you to sign this form to say you understand what you're doing. So it's not a heavy lift for the police officer. It really kind of balances out the power dynamic is, I guess, the way I would put it.
Senator Abbas.
Thank you, Mr. Chairman. And thank you for taking my question. And although I'm assuming this, in the real world, if the police are at someone's doorstep and they ask permission to voluntarily search their home, so they want to come inside and search because you're consenting to the search, isn't the person going to ask, why do you want to search my house?
Likely.
So at that point, if they're asking permission, wouldn't they understand that they're asking because they can't search it without their permission?
I'm not sure I understand your question. Yeah, the police are definitely, most individuals say, well, why do you want to search my home? And, it's up to the police how they respond to that, whether they say, for this reason, that reason, or maybe they get detailed and they say, we've got information that, et cetera. If the person, and they, at some point, before they get the consent, they got to tell them what this says they have to tell them. It may be, if they say immediately, sure, you can search my house, they say, okay, read this form and sign it if you agree to this. That's what would happen. As a practical matter, from the police perspective, and I've had these conversations with police, and with a car, with a home, why not try to get to consent to search? If you don't, you'll go back and see if you can generate enough to get probable cause to get a search warrant. So it's like it's kind of a throwaway effort. Throwaway might be not exactly the right word, but it's just like, why not try and get consent before we go through the process of getting a search warrant? So we just want to make sure that whoever is consenting has some more sense of what's at stake.
Go ahead, Senator.
Thank you, Mr. Chair. Thank you very much for taking my question. If you wouldn't mind, I'd like to move down a little bit further in the
Sure.
bill and address in lines 18 through 21, the significant period of time. And so could you just talk us through the significant period of time and how that, it's time. So there's a clock and it's ticking and it begins, and at some point as it keeps going, significant has been reached. How do we discern that?
Courts are actually good at doing that, and
Yep.
it plays out in this way. What this addresses is we don't want the police to go up to somebody's house and somebody answers the door and they say, we'd like to search your house. Will you consent to that? And they say, no, I don't want to consent. So they come back 15 minutes later and they keep coming back every 15 minutes, putting more pressure on the person. You know, there's Supreme Court case law on this, actually. We don't want that to be the case. We want there to be a significant break in time so that the person doesn't feel like they're under that pressure. There's a famous U.S. Supreme Court case where the police go to a place and ask for consent to search. And the wife and the husband answer the door. The husband, who's the target, says, no, you can't search. The husband later on, shortly after that, goes outside the house. They arrest the husband for whatever crime he was suspected of. They take him off to jail. And then the police go back to the wife and say, will you consent to searching the house? And she did. She did consent.
Okay, yeah.
So, that's a kind of an oddball case. They had probable cause to arrest the person. They just didn't have a search warrant. They needed a search warrant to search the house, and they hadn't gotten a search warrant. So they were just trying to, make it easy and see if they could do that. So, there's these number of cases out there where the concern is that you put somebody under pressure by coming back every 15 minutes. So we want a significant break of time. What judges will look at, given that body of case law that I talked to, they'll look at, does this really feel like they're coming back so often or so frequently without a break in time that they're really adding to the pressure on the person? That's really what that language is there for.
Can I follow up with something? Thank you. Thank you. I appreciate the clarification on there being a break in time. And I see that in line 20, there's the word and. So, and a new set of circumstances or facts have arisen. I think in your example, the new set of circumstances is that one of the members of that party was subsequently arrested.
Yes.
So, okay. So there has to be a change.
Yes.
To justify going back. Okay. So my next question, if we could go back up to line 5 and 6. And my question is, it says a law enforcement officer may legally conduct a search of a person's home or any other property. And so would that apply to a landlord and a tenant situation, or, a landlord occupied 2-family home? Like how does that work with the words and, or any other property?
As a general proposition, when we're talking about the Fourth Amendment, unlike it as it appears on television, where landlords and hotel managers are giving the police consent all the time to search somebody's room, they don't have, under the Fourth Amendment, they don't have the authority to give a consent to the police to search a room that they're renting to somebody else. So, I guess that's the simplest way to explain that. The purpose of or any other property was, a barn, a garage, a shed, any other property they own, that kind of thing, a suitcase. You the police don't have under the Fourth Amendment or the right to search a suitcase without the person's consent or without it meeting another search warrant exception. So that was the idea behind or any other property.
Thank you.
Andrea, was you good? You good? Okay. So, all right, thank you, Representative Chair.
And Chairman Roy apologizes for his conflict.
That's okay. We all have. Stephen Andres.
Good afternoon. My name is Stephen Endres. I'm a attorney I'm an assistant county attorney with the Merrimack County Attorney's Office. I have been a prosecutor for over 20 years, and I do oppose House Bill 162. In New Hampshire, all searches must be conducted either pursuant to a warrant or an exception to that warrant requirement. Consent is one of those exceptions, and that exception has been developed over a number of years through a body of case law. Consent in New Hampshire has to be knowing, intelligently, and freely given. Under current case law, there's no requirement that you inform a person of their right to refuse consent, and there's no requirement of a written form. And these aren't really new concepts. I say that because the case about not being required to inform a person of a right to refuse is actually in 1979. What happened in that case is that a woman who was at work was beaten and kidnapped. She was tied up and was moved to a house behind her workplace and was eventually found by her husband and the police. When they found her and they talked to her and said what happened, she explained what happened, described her assailant, said that he was wearing a red type jacket, that he had yellow rubber gloves on. She indicated that during the fight, she was able to stab him in the leg with something and that he was bleeding from the leg. She also mentioned that during the struggle, his watch band broke. So the police did what the police should do. They said, do you have any idea who did this? Do you have any suspects? And she indicated that she did, that there had been a man who had come into her real estate office a number of times over the last 2 weeks who she thought was suspicious. So the police talked to the chief of police, they talked to the postmaster, they found out where this person lives, and they went to his cottage. There was no one home. And obviously at this point, the police didn't have enough information for a search warrant, so they watched the cottage. And eventually this person came home, and the police did what they normally do, which is called a knock and talk. They simply went up to the door, knocked on the door. When he answered it, they said, do you mind if we talk to you for a minute? And I would say that's what the police are going to say. They're not going to start out by saying, can we search your house? They're going to say, can we talk to you for a second? He agreed to talk to them, invited them into the house. And then once the police were in the house, they noticed that on the table was a broken watch. They had a conversation with him and they said, do you mind if we look around a little bit while we're here? He said no. They looked in the bathroom, and in the bathroom was the jacket, a red jacket. There were yellow rubber gloves, and they noticed in the trash in the bathroom there were a number of bloody gauze. So at that point, they placed him under arrest. Now, if this bill passes and becomes law, at the point the police knock on the door, when they enter his house, they either need a warrant or an exception to the warrant requirement. In this case, when he said, sure, you can come in, that's consent. That's the exception to the warrant requirement. So in theory, in that case, while standing on the porch, the police would have to say to him before they crossed his threshold, we just want to inform you of a couple things. You have the right to refuse consent. You can't, So again, these aren't new ideas. There's no written form requirement in New Hampshire. And again, there's case law about that from 2004, where a company in Texas is raided for selling child sexual abuse images. And one of the subscribers happens to be a resident in New Hampshire, and they have information that this person 2 years ago had perhaps purchased child sexual abuse images. So again, the police do a knock and talk. They go, they knock on his door, they talk to him. He lets him into the house. He asks what it's about, and they say it's about, some computer fraud and some child sexual abuse images. He lets him into the house, lets him look at his computers, and sure enough, they find child sexual abuse images. Again, if this bill were to pass, they can't cross the threshold of that house without a consent to search form. The language within this bill, I think, is clunky, to say the least. What I had handed out was essentially a form that we had come up with in the Merrimack County Attorney's Office, which is a sample under the current law 595A10, the vehicle consent to search form. It goes through everything that the current statute requires you to inform a person of. On the flip side of that is what would be required under House Bill 162. And if you read what you actually have to inform the person of, paragraph C, I think is confusing at best. I can't imagine a police officer talking to someone on the porch and saying, you have the right to refuse consent. If you exercise that right, it can't be used against you. And if you refuse consent, I can't talk to you any further concerning consent unless a significant period of time has passed or the subject is raised by you. A significant period of time shall mean blah, blah, blah. But again, the statute requires that to be on this form. My experience with consent has been that there's not always a bright line point of consent, and there's not always time for a form. I certainly agree that a written form is the best practice, no doubt in my mind. The difficulty is that we can come up with 1,000 different scenarios here, and I can almost guarantee that as soon as the real world occurs, a scenario we've never thought of is going to pop up. I can tell you that shortly after 595A10 was passed, I think it became effective in October or November that year. The first case I had was a case where there were two teenagers in a car in a parking lot of a high school at about midnight with the windows half rolled down. A police officer pulls into the parking lot and can see smoke coming out of the windows of the car. So the police officer does what's appropriate. He stops pulls up behind the car, and not surprising, there's two people in the car smoking marijuana. Well, the car is, of course, not registered to the 16-year-old. The car is registered to the 16-year-old's mother. So the police call the mother. The mother shows up on scene. They take the 16-year-old not into custody, but put her back with the mother. And of course, the police say, before we release the car, do you mind if we look in it to make sure there's no further drugs? And the mother says, of course, please look in the car and make sure there's no other drugs in it. Well, the problem is that under 595A10, the mother, who actually owns the car, can't consent to it being searched, because 595A10 requires the driver to consent to the car being searched. So to say that this has been no problem, I don't think is realistic, because I know I've had a problem with it. I can give you another example of consent searches that I think this would become very problematic in. I had a case where an individual was in a dressing room in a store and noticed that over sort of the partial wall, they saw what looked like the top of a cell phone. The person quickly realized that the person in the dressing room next to them was taking pictures of them in the dressing room, and told somebody from the store. They called the police. The police showed up. We certainly know who the suspect was because he came out of the dressing room next door. And the police approach him, talk to him in the store, say, what are you doing? There's this accusation that you're taking pictures over the dressing room. He denies doing it, and the police say, well, do you have a cell phone? Well, right at that point, arguably that's a search, just asking him if he has a cell phone. But he agrees that he has a cell phone, and the police say, do you mind if we look in it? Do you mind just opening it up for us so that we can look at your pictures just to make sure you weren't doing this? Now, if this bill were to pass, they can't do that. They have to stop. They have to get out a form, get out a clipboard, get out a pen, and explain this to the person. In addition, one of the things that concerns me is that this bill has an exclusionary provision in lines 27 to 30 that says if this is violated, the results are inadmissible in any criminal proceeding. Now, the exclusionary rule is something that has been developed again through case law and is a fairly harsh remedy that you can't use the evidence in any criminal proceeding. It's not in any criminal proceeding. The exclusionary rule says you can't use the evidence in trial. So under case law, that exclusionary rule would say you can't use this evidence in trial, but you can use it in other criminal proceedings. For example, probation violations, you can still use evidence that wouldn't otherwise be subject to the exclusionary rule. In motions to impose, you can use evidence that would otherwise be subject to the exclusionary rule. In administrative license suspension hearings, you can use evidence that would otherwise be subject to the exclusionary rule. So the penalty provision within this statute actually goes further than what you would get for a constitutional violation. And to me, it doesn't make sense that the penalty for a statutory violation would be greater than the penalty for a constitutional violation. So I would encourage you to find this inexpedient to legislate, and I'm certainly happy to answer any questions. Yes.
So let's go back to your example. Why is it at the threshold? If I'm going in just to knock and talk, if that's not a pretext, if that's really why I'm going in,
Yes.
then when I saw the watch, then I could see, then I'm really searching, I'm looking around the room. Before I saw that watch, I might just be in there. Why do I have to do it before? Why wouldn't it wait till I've really started a search? So I just went in to have coffee, which I do with my local police.
So the test of whether or not the police need a warrant is whether or not the person has a reasonable expectation of privacy, and that's an expectation that society is willing to recognize. So certainly going into a person's house, the person has a reasonable expectation of privacy. So in general, if there is a police officer standing in your living room, they are violating the Constitution unless they have a warrant or an exception to the warrant requirement. So if you invite a police officer into your home to talk to you, you're consenting to them entering your home. So in my opinion, as soon as that officer steps off your front porch or out of your driveway into an area of your property where you have an expectation of privacy, at your invitation or asking, hey, do you mind if I come in for a second? They have consent to be on your property. And to me, under this bill, they need to have this form filled out.
You got it? Okay. Senator Adams.
Thank you, Mr. Chairman, and thank you for taking my question. I understand just from the plain reading of this, people may look at this as it's helpful to a private person who doesn't want, to make sure their rights are preserved. But maybe you can elaborate on when there is a search warrant, there's a scope of the search warrant, so the search is really narrow on what police can do when they're executing the warrant. Where with this, if they consent and it's in writing, I feel like it's not, you're kind of consenting to this, let them look through the whole house, where I think the warrant procedure really offers protections to people, even though it may not feel like that when you're being searched.
I do agree that a warrant needs to be narrowly tailored to what you're actually looking for. And, the example is always if you get a warrant to look for, machine guns, you can't go looking in places a machine gun wouldn't fit. Whereas I agree with you that when you have consent, you can search sort of wherever you have consent to search. One of the things with consent is that you always have the right to withdraw consent at any time. And I'm surprised that's not part of this form that says, I'm agreeing to consent, but understand I can withdraw my consent at any time. Because I'm certainly that's another argument that I think would be litigated. But I do agree that a consent search is generally more expansive than the search pursuant to a warrant.
Thank you.
All set?
Thank you.
Thank you very much for your testimony. Lieutenant Cataldo. Good afternoon, Lieutenant.
Good afternoon. Good afternoon, Chairman Gannon, members of the committee. My name is Lieutenant Derek Cataldo. I'm here testifying on behalf of the New Hampshire Association of Chiefs of Police in opposition to HB 162. So I'm going to just fill in a couple real-world examples where I think this bill is going to somewhat significantly impact law enforcement activities, particularly in the city of Manchester. I'll start off by saying I completely understand the intent. I think informed consent certainly has a place, and I think the reason that the courts and judicial doctrine stops at voluntary and free of coercion is kind of some of the examples I'm about to lay out. This bill expands informed consent to all property. So, like the representative said, it's people's homes, obviously people's vehicles as it stands now. This will be people's jackets, people's bags, people's cell phones, any property that they have. Something that we obviously have an issue with in Manchester is drug problem. We do a high level of street level drug interdiction. This would significantly impact that. So our officers are watching a problem drug house. They see someone coming out, put something in their pocket, put something in their jacket, put something in a bag, walk across the street. Our officers stop them. How it typically goes, they're very straightforward with these people. This is what we just saw. We see a bulge in your jacket. Do you mind if we grab it out? We assume this is some type of crack cocaine or some type of drug. Most of the time, they generally know what's happening. Okay, yes, take it out. That's a consent search. That interaction now requires a form that we need to fill out. Now, the issue with it in a situation like this is when a person has evidence of a crime on their person, officers want to deal with that as quickly as possible. The longer that you give that person to consider running, trying to pull it out of their pocket and eat it, discard it, destroy it, it becomes a serious issue and an officer safety issue. Now, this law leaves rooms for Terry Pats, which is pat down for weapons for officer safety, which is a different thing. We're generally looking for small amounts of drugs and street level interdiction. What I think will likely happen with this is officers will forego that and just seize whatever property they think the drug is in, which is going to deprive people of items of clothing, bags, wallets. And then they're going to have to seize it, bring it to the station, apply for a search warrant, which is going to tie up the officers in a significant amount of time. It's going to deprive these folks of their property, where if in the past they were likely to consent and the whole operation would move along rather quickly, which I think it kind of has the opposite effect of this. And I think officers are going to do this to avoid a very somewhat dangerous situation where they're negotiating consent, reading a form, putting a pen in someone's hand in an alley in Manchester when they're fairly certain they may have a finger of heroin in a bag or in their back pocket. That's one just basic thing that jumped out at me. Another issue is just basic calls for service. So like the gentleman before me outlined, anytime an officer goes inside a private residence outside of a warrantless exception, they need consent. So that includes, so we get called, we hear an officer is told by a neighbor, there's a male-female arguing, it's a basic domestic call. We go, we knock on the door, a female answers, hi, we got a call from a neighbor, do you mind if we come in? Sure, come on in. That's a consent to enter. At this point, without exigency, the officer needs to stand at that doorway and fill out a form with her before they can go in. This applies to an unruly juvenile call. Even if somebody calls us to their apartment, they're inviting us in, giving us consent. There's no cutout in this bill that I see that doesn't make room for that. They're still going to if you call for a burglary, I'm here to investigate a burglary that occurred last night. I'd like to come in your apartment. I need to go over this form with you before I can come in. Because the officer is entering the apartment without a warrant to search for evidence of a crime. I see nothing in this bill that would make an exception for officers doing that. They're still gonna, so basically every interaction when an officer enters somebody's apartment is gonna require a form, which obviously just hyper formalizes police interactions to a point which I think is somewhat unrealistic. Another issue that I see here is undercover operations. So undercover operations where we have undercover officers entering people's apartments, there's Supreme Court case law that allows them to be invited in, even though they're obscuring their true identity. Again, there's no cutout for that. So this will basically completely eliminate undercover police operations in the state of New Hampshire because the undercover officer would have to go over a form with somebody, obviously revealing their identity, which is just eliminating a huge tool that law enforcement has. Now, the exception in there is for constitutionally, I forgot the phrase, but basically constitutionally protected officer safety, which I think is the Terry v. Ohio case, which is a Terry Pat, which, I mean, I think it would obviously be litigated, but I do not believe that would cover undercover operations whatsoever. Another major concern with this bill. And finally, just the general issue with constant administrative burdens on officers. We ask officers to do proactive policing a great deal in the city of Manchester. It's a tool for crime suppression. When you start adding on form after form, the motor vehicle form is one thing. I think Senator Abbas made a point why that's a lot different. You're making a stop. The officer has a very clear advantage. They usually have backup. The people are separated from the car. That's one thing. When we're asking people to make a lot of pedestrian stops when there's reported drug activity at an address, we have a lot of motor vehicle thefts in an area late at night, things like that. And then anytime these officers are now wanting to search people, they have to fill out another form and go over with people and hand pens to suspects at 3 a.m. in an alley somewhere. This is going to be discouraging for them. I wish it wasn't, but it's just human nature that officers can get discouraged from engaging proactive policing when they have a high administrative burden, a high risk of issues coming up in court, mistakes. You're increasing the likelihood of officers just saying, forget it, I'll just drive by. I don't feel like doing a consent to search form in this guy right now. I don't want to deal with it. And I think that's obviously something we try and mitigate as supervisors for our agencies. When you have young officers, I think that's a reality of human nature that, should be considered when passing legislation like this, that is going to continually increase administrative burdens. So in conclusion, this is a major expansion from a very narrowly focused law that's focused on motor vehicles. This would impact thousands of officer interactions per day, require a form on almost close to the majority of our calls, I would think, at some point, and require major litigation to work out the ins and outs of how this would ultimately work out. But I'm happy to answer any questions.
Thank you. Yep, go ahead.
Mr. Chair, and thank you for taking my question. I'm looking on the back of the bill itself on page 2. And it does leave open. I think if I heard you correctly, that you were worried that the one of the worries is that it would create an excessive amount of forms to fill out, paperwork in order to follow through with regular policing.
Yes, ma'am.
And I don't think that the prime sponsor's intention is to throw a monkey wrench in the works. But
Certainly.
I hear your concerns. This does say, though, this section shall not preclude searches incident to arrest and searches justified by probable cause under exigent circumstances. So, I mean, that does leave that space for you to be able to do your job without necessarily having to engage in the form, right? It's just another tool, and not every knock and talk, if we're going to use that that phrasing, is necessarily looking for an opportunity to go inside. Is my experience with law enforcement. Am I incorrect there?
Yeah, I think that is
Okay.
very dependent on the type of call for service that we're going to.
Yeah.
I would say the majority of calls that people call us to their homes for, we typically end up going inside unless it's a direct complaint of something happening outside. Like domestics, we pretty much always will go inside to make sure no one's hurt inside, that we're missing eventually. Obviously burglaries, crimes that happen inside, things like that. And your point for the agency is certainly well taken. A concern I have with this is officers will err on the side of pushing exigency to its limits, where they'll start saying, well, I seized the drugs out of his pocket because it was exigent. He could have pulled them out and ate them. Or I had to go into that call because we got a call of two people arguing, even though they went up and they didn't hear anything and a woman came to the door on her own. But instead of reading the form, I thought it was exigent to go in, and I think you're going to see some of that from young officers where exigency will be stretched because they're going to be nervous about waiting. Whereas in the past we go, hey, can we come in? If you get a no at a domestic, then that you do further investigation on scene. If you get a yes, you're able to go in and go right in there. And then exigency is typically if you hear active issues going on
Right.
and no one's
Right.
answering. But your point's well taken, but I still think there's going to be a lot of instances where an interaction that would have been very quick, very clean, and very easily resolved with a sure, come on in, or sure, take a look, or is going to be just, like I said before, formalized and made into everything is a form, more or less.
So may I follow up, Mr. Chair? So let me give you a scenario that you've been called to a house for a well check by a family member, right? That doesn't live nearby. Can you please do a well check on my family member? And they live at, 1312 Cricket Lane. And so the two of you go over to 1312 Cricket Lane and you knock on the door. And the person that you're looking for comes to the door and you explain, hey, we got a call from your sister. She's a little worried about you. Do you mind if we, talk to you a little bit about, her concerns? This is a typical well visit, right?
Yep.
And this person invites you in and says, yeah, my sister gets all worked up and so on and so forth. So you are not there to do a search of the house. You are there to do a well check and to see that this person is indeed walking and talking and living and breathing and complaining about how their sister gets into their business, right?
Sure.
Now you have seen something that has raised an alarm bell. This is the point where you need to go get a warrant. If you had this, could you not say, hey, do you mind if we take a look around? And we'd like it if you would give us permission by signing off on this form.
Yes, I would say in that circumstance, if the issue is the person's well-being, honestly, we would probably just talk to them. But I do understand your point. That is understandable. Yeah, I think that is a realistic incident. Sure.
Okay, thank you.
Can I follow up on her? So
Yes, sir.
you're in the house, you were doing your well check for whatever reason, and then you see the bloody glove in the corner. You're then gonna ask, right, when you continue, then you'd start the search. That'd be really ground one of starting the search at that point.
I mean, that just entering the home on a welfare check, just to discuss well-being with someone that a relative was worried about. I think the issue is if you do see something like the Senator said, would it be argued later that was a search? I think most officers would just now take the invitation in where that is verbal consent. So if you happen to see some evidence of a crime that we have no idea is occurring inside, you're covered. Whereas now you need the form. And if you do go in with the form or with as we have it now with verbal consent, and you see some evidence of a crime, you would stop, come out, probably do a safety check, and then apply for a warrant. I think generally, I mean, searches of homes, I can't think of almost any in my career that have been done with consent. It's almost always,
So when you saw the bloody glove, you could then, it's an exigent circumstance, you could start your search.
well, you would search, so
You
what
wouldn't
we,
need to get a warrant right now.
we would search under exigency for safety. So we would make sure there's no one bleeding or dying in the apartment.
Okay.
Once we establish that, we would pull out and apply for a search warrant, and we do that because that is the cleanest and safest way to gather evidence. Because anytime you do consent to search, even with a form, this is why, I said before, very rarely will we, in the city of Manchester, will we do consent to search for a residence, because there can always be argument about how something was said, how it came across, what was done, how many officers were there, was the person seized, were they free to leave? There's always going to be issues with consent. That's why we typically err on the side of warrants when we can.
Very good, Lieutenant. I think, are we all set? Great. Thank you very much.
Thank you
Thanks
very
for your
much.
testimony. Major Bill Bright.
Good afternoon. Thank you for hearing my testimony. My name is Major Bill Bright. I'm a major with the New Hampshire State Police. Testified in front of this committee several times. There's been a lot of testimony about this already, so I don't want to take up a lot of your time and try and come up with more scenarios where this may be problematic. But we do see this as potentially problematic. The biggest reason for that, in my mind, is the language any other property that has already been discussed. I believe that the most of the talk from the sponsor of the bill and probably the intention of this bill focuses on homes, property in the sense of ownership of land or whatever those things may be. I don't think that the intent, I could be wrong, is meant to complicate regular police interactions with people. But when you add language like any other property, property can be defined as just about anything that somebody owns, whether that's a backpack, whether that's their pants pocket, anything basically in their possession. So if that's not the intent of this, then I think that is language that needs to be addressed in this bill. If it is the intent to include all of those things, many of the examples that were given are examples of why law enforcement is concerned about this bill, is that it will complicate regular interactions and not necessarily major investigations that are taking place. I think it was brought up at one point, it might have been in testimony at the House, but that police departments are getting written consent for most things anyways. And that's true. And that is certainly my intent when we're conducting an investigation. If I have the opportunity to get written consent, that's obviously the cleanest way to do that. In the language here, it's requiring either written consent or to have the consent documented by video and sound recording. And I think that the reason for that is because on motor vehicle stops, there are, many agencies that have cruiser cameras, body cameras, but there are still many agencies throughout the state that don't have body cameras and don't have cruiser cameras. So when you think about a regular police interaction where any property may be in play, as in a suspicious person call, and I'm walking through, the backwoods looking for a suspicious person, and I come across somebody, I may not have a body cam, I may not have a written consent form with me, I may not have necessarily any reason to detain that person for a long period of time, but I may say to them, hey, do you mind if I check, for whatever the case may be? Do you mind if I check for weapons? Do you mind if I check your pockets? Do you mind if I check your backpack that you're carrying? And if they don't have anything to do with the situation, the easiest thing for them to say is, yeah, sure, go ahead. And that's a normal interaction for police to have. In this case, we can't have that interaction anymore because we have to get written consent or document this by video or sound recording. So I think that if we are thinking of these possible scenarios where our searches could be challenged, I think that defense attorneys are going to think that every search that is conducted is reason to challenge. Whether there's written consent or not, it's going to be challenged based on some of the language in this bill. That would be our main concern, and that's all I'll have for you today.
Thank you very much.
Thank you.
Have a good day, Mr. Wright. No, you want to do it. Okay. We're going to go into executive session. So moved. Seconded. All in favor? Aye. So I'm going to do, want to make a motion?
On 162?
Yes.
Yes, I'll make a motion. I'll move inexpedient to legislate.
I'll second. Do you want to discuss further than what we've just heard from the police saying it's going to complicate their interactions? Do you further this?
The only other point I would raise, and this may be an unintended consequence, but the way it was written, it's the operator of the motor vehicle, but we're changing that to person. So that can potentially expand to the passengers consenting to search the vehicle when you're the one driving. I'm not sure if that's the intent of this. And I know an example we had where there was a stolen vehicle and they actually couldn't search the owner of the vehicle's car that was stolen because they needed the person who stole it to consent to it. So I've seen some problems with just the existing law, but I think changing it to person might have some additional unintended consequences. Also, I think the undercover law enforcement operation, which is something I didn't think about when I first read this. I think that's very persuasive to me. But,
Other thoughts?
Yeah, we've had this in front of us for about a hot minute and just discovered that there are some spaces where we could make some minor modifications and tossing it out without, really digging in and maybe making those modifications to, meet some of the objections of law enforcement, which I think we can do. Sorry about that. I don't know, I think this bill deserves the opportunity for us to have some discussion about amending it in a way that makes sense, not just chucking it out.
Okay. We just listened to everything. I thought it was fairly clear. I think Senator Amos did. So on the ITL motion, all in favor?
Aye.
Aye. Opposed?
No,
I'll take it up. Motion to move out of executive session.
I'm not gonna fight you.
All in favor of moving, we're moving out of exec.
We're
All in
moving out of
favor? Aye.
exec.
Okay. Thank you. Do you get 468? Thank you. Pretty fresh, yeah. Super fresh. I'll get it to you tomorrow. Representative Roy, come on up. Are you telling us 468, right? Is yours, I believe? Oh, okay, I'm sorry. I just saw your name up there. Representative Wheeler, how you doing?
Well, how are you, Mr. Chairman?
Doing great. Good to see you.
Good to see you as always. Thank you, Chairman and members and friends on the House Judiciary Committee. Almost demoted you folks. It's the Senate Judiciary Committee. You guys get a much more beautiful
We're
role.
all one legislature.
Well, I'm here today to introduce House Bill 468, which increases the penalties for unlawful unmanned drone usage in our state. This bill was introduced because of the gaps in the law that exist around drone usage currently in our state. So I'll very quickly go through some of the things that the other people who have signed up to testify will as well. The jails and prisons in our state are unable to address if a drone were to fly over and drop contraband. This legislation would fill that gap. The police officers, if a drone is flying over a situation that may be happening that the police are dealing with, this legislation would fill that gap. It essentially just raises the penalties for unlawful drone usage in our state. Very simple bill passed the House Criminal Justice and Public Safety Committee unanimously after an amendment, and this is where I'll say that it was the bill that was printed out in the back there was the original version of the bill. So if you had grabbed it from the table back there, you're looking at the original version of the bill. The bill did have an amendment. I have the number on my phone here, but I wouldn't be so stupid as to start tapping my phone when I'm on the desk here. The amendment was approved by the committee unanimously and essentially just fixed some of the language issues that were in the bill. So the bill, as amended, would allow the media to fly drones in the situation that they're not impeding on lawful usage or law enforcement's ability to do their job. And it also, in the amendment, changed, just looking for the exact section here, it's around line 25, line 28, where it is going through FAA restricted airspace over the property of a federal or state correctional, penal, or detention facility. The amendment made it so it would say federal, state, or county correctional facility, and then added the word county into the other paragraph as well, because state and county correctional facilities are different. So with that, Mr. Chairman, this is something that needs to be dealt with across the country. Places like Langley Air Force Base, there was a story on 60 Minutes the other day about the 100 or so, they couldn't really count how many drones were overhead, but these unmanned, undetected drones were somehow shutting down Langley Air Force Base, one of the most sensitive military installations in the country. Now, I have some friends that tell me those are alien drones. We don't know if that's true. And all we can deal with really right here is the actual drones here in the state of New Hampshire. That is a problem. And there are people from the state prison, the Department of Corrections, the Space Force agencies, and others here who will testify and who can speak to this legislation a lot more specific than I can. But I'm happy to answer any questions.
Thank you. You all set? Oh, no, we have a question.
Thank you, Mr. Chair. Thank you, Representative, for taking my question. Could you show me where in the bill news outlets are?
So, Senator, as I said in my testimony, the bill that was handed out to you in the back doesn't include the amendment that was written in. So, as I said in my testimony, the amendment, as it was approved by the committee unanimously, is what includes that news section that you're looking for.
Yeah, I think I was looking for you to tell me it was just line 18, but thank you.
Okay.
Thank you very much for your testimony.
Thank you very much, Mr. Chairman and members of the committee.
Have a good one. Officer Christopher Ball. You certainly can. We love when two testify. 2 for 1s are very efficient use of time. I
Thank you, Mr. Chairman, and members of the committee. My name is Christopher Ball, representative from the New Hampshire State Police, representing the Department of Safety here today. And here is Adam Siridelli, who's going to assist me here at the table.
Good afternoon, Chairman, Senators. Thank you for your time. Adam Chardelli. So for a number of years, I was a state employee supporting the New Hampshire Information Analysis Center UAS Threat Work Group. More currently, a private sector partner. Still help with consulting for counterterrorism efforts for the State Fusion Center and State Police. And I'm here to help Trooper Ball with any threat-based questions or inquiries that you might have. Thank you.
Thank you, Adam. So members of the committee, as Representative Wheeler stated so well, is that this is some important legislation that we feel needs to be adopted by the state of New Hampshire, specifically into the regards of nefarious or illegal UAS or drone operations within the state. As I know you're aware, currently New Hampshire law does not have any regulations prohibiting the nefarious or criminal use of drones within the state. And this law would simply adopt some federal regulations, Title 49, Part 107 of the federal regulations which govern drone use throughout the country. It'd simply codify those rules under New Hampshire law. And what that would do is give New Hampshire law enforcement a mechanism or tool to use in the event that nefarious drone operations occur or criminal drone operations occur within the state, that New Hampshire law enforcement could take action in those cases. Legislation has been a collaborative effort between the Department of Transportation, Aeronautics, the Department of Corrections, and many other private and public stakeholders throughout the state to get this legislation written in the way that it currently is. So the Department of Safety's perspective is that we would love to see this legislation adopted underneath the way that is currently written, and we would ask you to move forward with this legislation if you so see fit. Thank you. I'll be happy to take any questions.
Thank you both very much. Do we have any questions? Seeing none, thank you both.
Thank you.
David Dinwoody of the U.S. Space Force. I'm still not used to saying Space Force yet, but I'm gonna get there. Do you remember Space Ghost?
I don't.
Old? You're not as old as I am. Never mind. You do remember. I know you. We'll move on. Good to see you.
Thank you. Thank you for having the hearing today. Generally, I'm here to support the bill and speak in favor of it with a caveat that I'd like to speak with you about. As I said, for the record, my name is David Dinwoody. I'm the Defense Force Director for the New Boston Space Force Station. So I'm going to speak to you specifically today related to the concerns of the New Boston Space Force Station. For those of you that aren't aware, the New Boston Space Force Station is the only active duty military installation in the state of New Hampshire. It's the home of the 23rd Space Operations Squadron, and the 23rd Space Operations Squadron is one of only 7 worldwide ground stations for the United States military satellite control network. So what we do at the New Boston Space Force Station is we provide on-orbit tracking, telemetry, commanding of over 200 satellites that are for the Department of Defense and partner agencies. Our satellites do a variety of missions from intelligence, weather, navigation, early warning, and communications. New Boston Space Force Station is kind of a unique military installation where you've probably heard of many that have exclusive jurisdiction, meaning only federal laws apply on the military installation. New Boston Space Force Station is different. We have concurrent jurisdiction, meaning that all the state laws in the state of New Hampshire apply on New Boston Space Force Station, as do federal regulations as well. And so we rely heavily at New Boston Space Force Station on our local law enforcement partners and the state police as well. I'm a retired New Hampshire trooper. We've got a fantastic relationship with New Boston Police Department, Amherst Police, Mount Vernon Police. All 3 of those towns encompass the 2,700 acres of New Boston Space Force Station. We have no assigned law enforcement personnel on the installation. None of our security personnel, whether they work for the government or for a contractor, have the authority to arrest anyone. And so we rely on memorandums of understanding with our local law enforcement partners for enforcement of laws. And so one of the threats that we face within the military, as Representative Wheeler spoke about related to Langley Air Force Base, is unmanned aerial systems. It is grown increasing in numbers, and the threat has become significant. Our concern, obviously, as you've probably seen on the news, is these drones could be doing a variety of things. They could be collecting intelligence. They could be delivering payloads, which could be ordnance. They could be interfering with radio frequency communications. And for us at the New Boston Space Force Station, for our mission, that's probably our biggest threat, is interference with our mission. Our installation is designated as critical to the warfighting capability of the United States military. And that's an official designation. That's not my opinion. So one of the concerns we have in this bill is the fact that unlike the Senate bill, this bill doesn't specifically address military installations. This bill relates to the Code of Federal Regulation, Part 107, as Trooper Ball spoke about. So New Boston Air Force Station has restricted airspace above it. And so that's how 14th Code of Federal Regulation, Part 107, applies to New Boston Space Force Station in the same way it applies to any place that has restricted airspace. Unfortunately, it's not a deterrent. And we've had incursions of UAS literally as recently as last week. We had multiple drone incursions last week. So both this House bill and Senate Bill 49 are set to address this issue of unmanned aerial systems. And so in the Senate bill, it has been amended so that in the sentence that relates to the property of federal, state, and county correctional facilities, there was an amendment that added "or over military installations." And that was my team's efforts to get that amendment added in, and that's a critical amendment. Currently, the language in the House bill only provides for a violation level offense if somebody violates 14 CFR Part 107. I believe that language is insufficient to protect the installation and our critical defense, national defense mission. It says a violation for a first offense and a misdemeanor for a second offense. Imagine that a team of adversaries of just 5 people who are our adversaries are willing to swap off and each take a violation level offense, and it's the equivalent of a speeding ticket over one of 7 worldwide ground stations protecting our military, communicating with the satellites. In my mind, having a level of offense analogous to a speeding ticket protecting a military installation doesn't make sense to me. And I would urge you to consider an amendment to this wonderful bill to include specific language similar to the Senate bill that would specifically call out military installations. I think it's critical to the success of our mission and protecting our national defense infrastructure. I'm happy to answer any questions that you have.
Just so you know, I do have that amendment. We just haven't got it passed around, so it'll be in there with over the military installation. I'll circulate that before.
There's an intention to amend it, Senator.
Thank you. Do we have any questions? Okay, get out late. We'll get it before we exam. Any? Debbie Olson? What's that? Okay. Thank you very much for your testimony.
Thank you very much.
Hold on one second. Jane Graham.
Good afternoon, Mr. Chairman, members of the committee. My name is Jane Graham. I'm the Strategic Communications Administrator for the New Hampshire Department of Corrections, and I'm here today to testify in support of HB 468. We had previously testified in front of this committee in support of SB 49 as well, so I will keep my testimony brief. However, drones are increasingly being used for unlawful activity in and around correctional facilities. There's currently protection for the prevention of drone activity when it comes to federal correctional facilities, but this protection does not extend to state correctional facilities, and we're looking to have that protection as well. Drones have been used across the country to smuggle illegal contraband into facilities, such as illegal drugs, weapons, cell phones, and other prohibited materials. In some cases, drones have been used to surveil correctional facilities as well to help aid in escape. So we look at this as a critical tool to help enhance the safety and security of our facilities. That is it for me, and I appreciate your consideration. I'm happy to answer any questions if you have any. Thank you.
Does anyone else wish to sign in who didn't have the opportunity? Seeing none, that'll end the hearing. Representative Roy, do you want to introduce this for Jonah, or? Thanks. Or were you going to introduce? Oh, it's your bill. Okay. He signed first, so I thought, okay. Good afternoon. Sorry to keep you here so long this afternoon.
Good afternoon, Senators. My name is Representative Terry Roy. I represent Rockingham 32. I'm also the chairman of the House Criminal Justice and Public Safety Committee. The bill I bring before you today is at the request of Director Skipper of the law enforcement training. The issue that this is necessitates this bill is that we want our best and brightest to teach our new police recruits. And it's difficult to do that when it means an automatic pay cut for them to go teach at the academy. Under the current statutory situation, sworn officers who work at the academy can't take details. As such, that's an enormous pay cut right out of the gate coming over there. So this bill would just simply let them, under a mutual aid agreement, take details, and then they could be better compensated. And that's really the nuts and bolts of it.
I like nice, straightforward bills. Thank you. Any questions? Seeing none, thank you.
Thank you.
John Skipper, you here? There you are. Good afternoon, Mr. Skipper. How are you doing today?
I'm doing well, Mr. Chairman.
Great.
For the record, my name is John Skipper. I'm the Director of New Hampshire Police Standards and Training. With me is the Assistant Director, O'Brien. We are here in support of this bill. We'd like to take this opportunity to thank Representative Roy for putting it forward. And really, this bill allows me and our agency to address really two different kinds of concerns. In the first instance, we are often contacted by other law enforcement agencies who are in need of some extra help during certain events. I can tell you that we routinely get called by Hampton PD, Loudoun PD, Guilford PD, depending on what they have going on in their particular communities. As we all know that, really right now there is some staffing issues that are not only specific to New Hampshire, but across the country with regard to law enforcement officers. And so oftentimes these communities need a little bit of extra help. We would love to be able to send our folks to augment those local communities at the request of the chief law enforcement officer, but we really don't have anything in statute that would allow us to do that. Secondarily, I think it's also important to recognize that I'm kind of fishing in the same pool as every other police agency. The people who train the police are police officers, and they have left their agencies to work at the academy. And in doing so, they've kind of stepped away from the opportunity to make a little bit of extra money. And that is something that did impact them negatively by coming to the academy to work. This certainly would allow them the opportunity to kind of make some extra money on top of that. And we appreciate your time, and we stand ready to answer any questions you might have.
Thank you. Do you want to testify also?
No, I think Director Skipper said it all, sir.
Okay, sounds
Thank
good.
you.
Good answer. Senator.
Thank you, Mr. Chair, and thank you, Director Skipper, for taking my call. Nice to see you here. Could you just clarify for me that law enforcement training specialist is also a word for teacher?
They have a dual role. They're police officers, and they are the lead instructors at the New Hampshire Police Academy.
And this in no way opens the door for someone who may be performing in a TA type role that is not finished with their work, but this is someone who is in a teaching capacity, right?
Just so that I understand.
Teaching assistant, we're not doing, yeah, thank you.
No,
Just wanted to get it out there. Yep.
thank you.
Senator, go ahead.
Thank you, Mr. Chairman. Director Skipper, nice to see you. I'm more familiar with facility as opposed to personnel. How many personnel do you have typically assigned to your facility?
Presently, we have 12 full-time police officers that work as training specialists.
If I could follow up. So is the goal here to provide an opportunity for them to do a detail or two, or to assist in a limited capacity? This isn't, I would assume this personnel, which are sorely needed, are needed at that facility, but this is on an interim basis, they'd be permitted to go out and help somewhere else.
Thank you, Senator. Yes, that is absolutely accurate. They clearly have a priority with their job at the police academy. This would be, a weekend or an evening that they're free.
Thank you, Director. Thank you, Mr. Chairman.
Thank you.
Thank you both.
Thank you so much.
Senator Birdsell, did you want to add? Yeah, you have an amendment, I believe. I hadn't totally forgot about you. If you hadn't come in, I wouldn't have remembered. Good afternoon.
Good afternoon, Mr. Chair and committee. For the record, my name is Regina Birdsell, State Senator for District 19, the towns of Derry, Hampstead, and Windham. And I think you have in your packets Amendment 1382S. I have spoken with the prime sponsor, and he was agreeable to put this amendment on. What this...
Excuse me, I'm sorry. Peter, do you have a copy of that?
I have plenty.
Okay, great. Thank you. It's short, we like that. Go ahead.
Well, as you recall, last year we passed the Violent Action Disability Retirement piece. And in implementing it, what happened is on line 12, you'll see the current language says the member is found to be mentally or physically incapacitated for further performance of duty. That was not the intent of the piece of legislation, and what happened is the retirement system is notifying individuals who have PTSD, which PTSD is covered under another statute of retirement. So we wanted to correct it and put the member is found to be physically incapacitated for further performance of duty, because this is for individuals who have suffered from a violent act, like the two officers from
Ware and Dan Doherty and Paul Lewis. And that's what this does, is correct that violent act retirement.
Any questions? Go ahead, Senator. Oh, shall I? Yep.
Thank you. Yeah, thank you, Mr. Chair. Thank you for taking my question. I'm just switching gears because just had this for a hot second. Why do we want to take out mental incapacitation if that incapacity is likely to be permanent, particularly for people who have experienced severe trauma?
Because the PTSD is already covered under other types of retirement. This was only for those that suffered from a violent act, like being shot or hit by a car for purposely. And that's in the description in the original bill.
Okay, thank you. I don't have the original bill in front of me, so I'm just trying to catch up here.
Yep.
So if someone had been shot and also suffered from PTSD from that violent incident, the coverage for the PTSD related to that violent incident is found somewhere else in House Bill 778?
So, you mean 778?
That's what you just handed me.
Oh, this is the amendment.
Amendment to 1382 to 778. Yeah.
What happens is PTSD is covered under workers' comp capability, and that's what happens with PTSD. The violent act, if they are permanently disabled because of that violent act and they're found, and the commissioner of safety usually determines that, like he did with Officer Lewis and Officer Doherty, then he recommends it and sends it to the retirement system, and they start processing it.
One more. So, yeah, thank you. So, in the space where PTSD is covered under the workers' comp section already, does that also, within that section, because I don't have it in front of me, address incapacitation from further performance of duty due to that mental condition?
If workers' comp finds them incapacitated because of PTSD,
Yeah.
I believe they send it and unable to continue working because of the PTSD, then they can apply for a disability retirement, a straight disability retirement. This retirement is only for violent action disability retirement. And we changed a little bit of the benefits for them who were on the violent act to kind of boost it up a little.
Okay, thank you. I'm just trying to make sure they're not edged out and receiving less than in another place than would be here. So,
Right.
yeah,
We
just trying to figure out where it balances.
We actually discussed this as I'm the chair of the PTSD Commission. We actually discussed this in the PTSD Commission, and they agreed that this disability violent action should be separate than the PTSD.
Thank you. That's helpful to hear. Thank you so much.
Yep.
Thank you, Senator. We're all set.
Thank you.
Does anyone else wish to testify on 778? Seeing none, that'll end the hearing. We're good. What? We're not going to do anything now. We're good. Okay. We're all set, Pete. Anything else you want to cover? Good. Okay. So I ended the hearing. We're up. Adjourn? Motion to adjourn. Daryl, thank you. Second by McConkey. We're out. All in favor? Opposed? Nobody? We're out of here.